So thank you very much, Mr. Agira, the chair of KCSFA, Kenya CyberSecurity Forensics Association, in conjunction with KMJA, Kenya Magistrates and Judges Association, of which I'm the president. So we welcome you to this webinar on cyber forensics, the justice perspective. Today, we are very privileged to have very, very distinguished speakers, Justice William Musyoki and Mr. Peter Mbatha. I will just give you a brief biodata of Justice Musyoki. He was admitted at the bar in November 1991. He taught at the University of Nairobi School of Law and Kenya School of Law. So I believe there are very many students of his who will probably be listening to him and benefit out of this interaction. He taught law of succession, family law, criminal law, among others. He has published texts on law of succession and criminal law. Before he joined the bench, and that was in 2012, he was in active practice as an advocate. And he has served at Kirugoya, Nairobi, and is currently the presiding judge at Kakamega. So welcome very much, Justice Musyoki. The next speaker that we're going to have is also very distinguished and an expert in this area. He's an expert in law enforcement, and this is Peter Mbatha. His expertise in cybercrime investigation and digital forensic work. He's in the DCI Digital Forensics Unit, police, for the last 13 years, and in the cyber forensics for 4 years. His academic qualifications are BSc IT in KCA University, MSc Distributed Computing Technology, and from the University of Nairobi. So we wish to welcome both speakers. And at this stage, I want to encourage all the participants to write questions. There's an icon for writing questions. If you want to pose the question, to ask questions, and you can indicate to which expert you're leveling the questions to. So thank you very much also, Mr. Wahome and Dan Sepu from the two associations for the technical support in the background. So as you've heard, my name is Justice Jackie Kamau. I'm the president of the Kenya Magistrates and Judges Association. So at this point, let me introduce and welcome Peter Mbatha to make his presentation. Mr. Peter Mbatha, please take the floor and talk to us. Thank you very much.
Good evening, everybody, and thank you for this opportunity, Justice Kamau. For introduction, you've heard, name Peter, currently at the DCI, Digital Forensics Lab, whereby we are working from as an individual and as the DCI. So, first of all, learn to understand the meaning of the word digital forensics, whereby as many may define it either academically or from the aspect of law enforcement as an application of scientific methods in investigation, rather techniques towards handling criminal crimes, would equally be defined as a process of preserving, identifying, extracting, and documenting digital evidence where applicable, with one goal, that is to preserve the evidence in its digital form while performing investigation with the sole purpose of using the same in any court of law. Since we've defined and understood the goal and the purpose for the exercise, or rather the procedure called digital forensics, towards tackling the menace of cybercrime, as we all aware, the only reason why we handle issues to do with digital forensics is because of the aspect of cybercrime, which are crimes committed through or using digital or cyber aspects. Digital forensics is essentially classified differently depending on the aspect of digital forensics. We got mobile phones forensics, we got system forensics, which rotates between networks and systems, what people mostly call servers. In our today's webinar, I'm going to emphasize mostly on XBIT management, because that's where everything begins. What are XBIT first? XBIT is anything that is of digital nature in this instance, from which digital evidence can be acquired from for the sole purpose we had initially stated, that is for use in any court of law. So, what are these aspects that we need to consider before we secure any XBIT for acquisition of any digital evidence? We need to consider the type of evidence that is contained in the said XBIT, because as we understand from the technical point of view, that we have XBITs that contain old volatile evidence and volatile data that forms part of evidence, and others contain non-volatile data, which also forms part of the evidence that you're going to look for in any investigation that you're going to conduct. Why is this important, if we may ask? This is because this provides fundamental skills and knowledge on steps to follow for best practices when conducting any cyber investigations and digital evidence. Many guys will ask me why I'm talking about the skills and knowledge, and that they already are have the skill set and know-how of handling systems and digital materials all together. We need to be sound in the way we handle the XBITs that contain XBITs, so that we may not interfere with any said, rather any possible evidence that may be required to be produced in any court of law. So, what are these best practices when handling digital XBITs? Before and any time when you are supposed to handle any XBITs that contain or possibly contain any digital evidence, there are certain aspects that we should put into consideration. First, will be we need to seek consent to search for any available XBITs from either the suspect or any other person who may be owning them. This ensures that we don't have wars with the owners of the XBIT. When we acquire XBITs from the evidence from the XBITs, and we're supposed to present it for any legal purposes. This can also be enforced using a court order, which is acquired from any court of law, which allows any investigator or any other person who is supposed to handle the XBITs to legally be in possession of them. On the other case, you can find yourself in a situation whereby you have acquired or rather retained exhibits from either a scene of crime, whereby those exhibits were found and collected from the scene, and possibly they need to be investigated to define who the owners are. So those are some of the aspects whereby you find yourself supposed to handle the exhibits, and you need to immediately, once you have the rightful ownership of any exhibit as an investigator, you require immediately to prepare an inventory, which is a legal document which defines what kind of exhibits you acquired by describing them and identifying any features that may be used to uniquely identify the exhibits when producing them. In addition to that, you're required to prepare a chain of custody. This is supposed to be by the person who is seizing the exhibit, and it's supposed to be a document that has to be signed, or rather be appreciated by anybody who's supposed to come to the said exhibit for as long as they're going to be held for the purpose of digital forensics or any cybercrime investigations. Once these exhibits have been documented, they're supposed to be delivered to a forensics lab, whereby they're supposed to be worked on condition that the end result will be to produce a report that will be used for court purposes. So immediately after you're done working on the exhibits, you prepare a report, and such a report must be accompanied by something called a certificate of production of digital evidence, as stipulated under the Evidence Act in Section 658 and Section 106B4. So such procedures ensure that whatever exhibit that we are handling towards acquisition of any sound, of any digital evidence, are handled in a manner that is sound and can be trailed back to the source of such exhibits, and thus will not raise issues on who owns what digital exhibits and what evidence is inside them, or rather, who acquired whatever exhibit evidence is in the exhibits. So, having followed such a procedure, foresees a well-managed exhibit handling procedure that does not raise issues towards any exhibits that are supposed to be produced any court of law. And as I finalize on the issue of exhibit management, I want to reiterate that exhibit management is the most fundamental bit of any exhibit that is supposed to be acquired and adduced in any court of law for any legal procedures, because if we fail to handle exhibits in the right way, we lose on the integrity of whatever evidence we're going to acquire from such exhibits, and thus the report that we're going to produce from the same will be questionable. So it is advisable for cybercrime investigators and digital forensic experts to consider how they handle their exhibits so that they ensure a seamless handling of such exhibits for any matter that they are handling. With those few remarks on exhibit management, I want to hand over the session to Justice Kamau to continue with, who is our moderator, to continue with the session.
Thank you very much, Mbatha, for that very well elucidated conversation. I can see a few comments are coming in, so we hope that we will continue to have a candid conversation. Even as you think about it, you might probably want to tell us what is distributed computing technology. It's very sophisticated, MSc in that from the University of Nairobi. So at this point, I want to call Justice Musyoki, presiding judge from Kakamega. As you've heard, he's a teacher. So we hope that he's going to give us his perspective, the justice perspective, as far as these cyber forensics are concerned. So welcome, Justice Musyoki, to speak to us. Thank you.
Thank you very much, Justice Kamau, for introduction and for inviting me to make my presentation. Let me start by, first of all, define.
Judge, you can unmute your video.
Yes. Thank you. Thank you very much, Justice Kamau, for giving me this opportunity to make my presentation on the justice perspective on digital forensics or cyber forensics in general. I would start by defining forensics. The word is derived from a Latin word, forensis, which basically means open court or public, and therefore forensics have everything to do with a court, and it is commonly used in modern times to refer to application of scientific methods in the investigation of crime. That then would mean that forensics are to be applied basically for the purpose of gathering evidence for presentation in court. And therefore, when we talk about digital or forensic or cyber forensics, we really are basically talking about presentation of evidence in court, evidence that has been generated from computers and other digital storage media. And therefore, my presentation is limited by that definition to production or presentation in court of evidence that has been generated from computers and other digital storage media. My co-presenter has made reference to the Evidence Act. The Evidence Act is essentially the source of law in Kenya related, and he has made reference to Section 106 of that Act. In addition to Section 106, there's also Section 65 and 78. 65 is in the part of the law dealing with documentary evidence, and essentially it provides that, sorry, can't hear me? Hello?
We can hear you, Justice Musyoki. I think for the ones who are not
Yes.
speaking, we can kindly mute so that we can give Justice Musyoki an opportunity.
Thank you. Yes, so I'm saying that Section 65 essentially deals with computer printouts. So the evidence being presented in court, it takes the form of computer printouts. Then Section 65 will deal with that, and it provides that such documents are to be treated as primary evidence without having to produce the original documents, providing that they meet certain conditions. And those are the conditions that Peter was referring to. That is the source of those documents, the process of procuring them, the custody, and the delivery of those documents must be brought out to the court, and we shall see at the end of it that this is intended for the purpose of ensuring that the documents are authentic and that they were obtained and produced in a process that is authentic, a process that has integrity. And in addition to that, the documents must be supported by a certificate which sets out how the document, or the printout rather, was generated in terms of disclosing the source of the documents, who had custody of them, and how the printout was processed in terms of disclosing the equipment that was used for that purpose. Then there's Section 78 of the Evidence Act, which deals mainly with admissibility of electronic and digital evidence. And this primarily relates to electronic messages and other digital material, SMSs and WhatsApp messages and the like. These are again admissible as evidence so long as conditions set out in Section 78 have been met, relating to how the material has been generated, how it has been stored, how it has been communicated, essentially talking about the source of the information or the data, how that data has been generated or processed, who has custody or who had custody of such material, and so forth. Then 106, which my colleague referred to, is in the part of the law which deals with proof of electronic records in general. 106B provides for admission of electronic records, that is data which is in electronic record, whether it is printed or stored or copied on an optical or electromagnetic media, whether produced by a computer, that is, it shall be deemed or treated as a document for the purposes of evidence, and the same can be produced as evidence so long as it meets the conditions as to source, process, delivery, and the custody. For it to be accepted by the court as evidence, again, it must be supported by a certificate in terms of Section 106B, subsection 4, disclosing the source of the document, the process of the generation of that document, and delivery.
Yeah.
Other portions of Section 106 deal with such matters as proof of electronic signatures and presumptions that may be made with respect to certain types of electronic records, such as production of Kenya Gazette notices and the like. I would like to say that Section 78A, that is the one relating to evidence on electronic messages and other digital material which are not covered by Section 65, ought to be read together with Section 106B, and that is with respect to certification, so that any document or any material, electronic material, digital material, or evidence that is being admitted on the strength of Section 78A must be supported by the certificate that is required under Section 106B, subsection 4. You will notice that these two provisions, that is Section 65(8) and 106B, subsection 4, all require that this electronic material that is being placed before the judge or the magistrate must be supported by be asking and you have this certificate. In fact, case law will show that the evidence will not be accepted if it is not supported by that certificate because the requirement under 65(8) and 106(b)(4 are mandatory. I would refer you to some two cases where the court interpreted or explained the importance of this certificate. There's one is not a criminal case, actually. Even though we've discussed it in the context of criminal evidence, these provisions apply also to civil matters, and much of the case law hinges around civil matters. In this one particular case, it was emphasized, the case of Julius Makau Malombe, that the certificate is required for the purpose of reliability, authentication, and the integrity of that evidence in terms of disclosing the source of the material, how the material was handled, up to the point of generating the report that Peter was talking about. And therefore, the certificate serves the purpose of showing that the evidence is reliable, it's from a reliable source, it's authentic, and it has integrity, and therefore the court can place importance. The point is that electronic records are generally more susceptible to tampering, alteration, transposition, excision, and such like. And the safeguards in section 65(8) and 106(b) and 4, requiring certification, among others, is intended to protect the evidence from such tampering or excision or interference. There's also another case of Idris Abdullahi, where the court emphasized that before any court can admit electronic or digital evidence, the certificate is mandatory to confirm the source, the process, the delivery, and custody of the electronic record so as to preempt manipulation of the record, essentially just emphasizing what the court in the other case had said. And also in the case of William Oduor, the court stated that the certificate is intended for what the court described as an audit purpose, so that any person who may wish to trace the source of the document can, from the information in the certificate, be able to follow the footprints through which the said electronic material was processed for the purpose of presentation to court. If it's material that was produced using a digital camera, it is possible to trace it from that digital camera up to the point where the report that Peter was referring to is prepared. How the same is transferred from the camera to a computer, and then from that computer to some form of print, so that the same can then be presented to court. So what form should this certificate take? There's an issue that comes up in court every now and then, and I think the Court of Appeal has laid this to rest in a case here called County Assembly of Kisumu versus Kisumu County Service Board, where the court said that the law does not make provision for a particular format, and therefore it can be a certificate in the usual way, where the person producing it certifies that the report that is being placed before the court is authentic, and gives details of the steps that he took in the process of generating the material that is being placed before the court. It can also take the form of an affidavit. The producer or the person seeking to produce the document or the report can swear an affidavit giving details of how he processed the digital evidence in question. One issue that arises is with regard to Article 159, because this certificate is a matter of evidence, it's a matter of procedure rather, because you're saying for you to rely on this document, for the court to rely on the digital material that has been collected as evidence by the investigators, you require a certificate. And therefore, this makes it a matter of procedure. It's a technical matter for that reason. And one can argue that under Article 159, the court can overlook the certificate because it is a matter of procedure, it's a matter of technicality. The courts that have been faced with this have taken the view that since it is a mandatory requirement of the law, going to substance, the substance of the matter, it is not hosted by Article 159 of the Constitution. And therefore, it is still a mandatory requirement of the law, and the person seeking to rely on such evidence must produce that certificate if they expect the court to rely on the electronic material that they want to place before the court. Essentially, that is basically what I had by way of presentation. Thank you very much.
Thank you very much, Justice Musyoki. I was just about to tell you that your time was up, but I can see that you have kept the time, so thank you very much. So we want to start on the plenary, and already I can see a question here by Alino Riquena. I don't know whether he's, and there's also another question. Maybe I can read. Is that the question goes to the, I think, detective panelist. Poorly reasoned, validated, and presented digital evidence can result in conviction of the innocent as well as acquittal of the guilty. Do you agree with me? If yes, how have you ensured that all the aspects are captured while considering that we currently don't have SOPs on this area? And then the second question was, kindly demonstrate how the forensic evidence presented before courts maintains integrity and untampering. There's also another question that says, kindly share on the Computer Misuse and Cybercrime Act. Will this act borrow from electronic evidence? Is it high time that we establish a cybercrime court in Kenya? Perhaps maybe Justice Musyoki, you can deal that. Any of you can deal with it. Are our judges supposed to understand the technical processes of digital forensics in our courts? 4, is there a difference between the electronic records and digital forensics? Now, for the panelists, I can see there are quite a number of questions. Can DCI establish a cybercrime unit? And another question to Justice Musyoki, and I think that was one of the poorly validated evidence. So the request also is that you can go to the chats and you can see these questions so that you're able to understand them, because maybe I may have written very quickly. But the other request that we'd also want to have is Peter and Mbatha and Justice Musyoki, whether you can turn on your videos so that we can be able to see you. I think I've turned on mine, so we want you to turn on yours. Or Justice Musyoki can take the floor. Maybe I can just with who is going to start? Can you please kindly start?
I'll start by responding to the first question by Alironi, and agree with him that poorly reasoned, validated, and presented digital evidence can result into a conviction of innocent as well as acquittal of the guilty. That's true. I want to remind him that, or rather, I want to reiterate this, that digital evidence touches on fact, something that can be reasoned to its source. In this, I'm saying any evidence that has been acquired should there be a question of identity, the same XB should be subject to the same procedure, and similar results should be achieved by any other expert who will be handling the same. In that, I mean, any expert who is supposed to work on any digital evidence should maintain integrity of the same, and this is done by something we call creating hash values for each and every evidence that you're going to produce, since it is recommended that you don't work on the original XB, but you acquire a copy of the digital evidence that you're going to work on, such that when there are issues related to integrity, the same XBit are subjected to the same process again, and the same result should be achieved by whoever is handling the same. On the other aspect of standard operating procedures, I want to categorically say that for anybody who wants to establish any digital forensics lab, be it an organization, be it any institution that may be, the first guiding thing is the standard operating procedures, which define your mode of operation and any action that you're going to take, which should comply with international standards as laid up by the societies that regulate the establishment of digital forensics labs. We also got ISO certifications for the same, and I want to promise you that you cannot deliver on any aspect of digital forensics without following a laid down stipulation, and that is the standard operating procedures. So I'll allow Justice Musyoki to answer the other question, as then later I'll get to answer the other question by Odanga.
Okay, thank you, Peter. Starting with the question of the integrity of the record and how to determine the same. Let me start by saying that going by the Evidence Act, the principal consideration by the court is whether or not the certificate on record is proper in terms of capturing the requirements of Section 106(b)(4) and 65(8), detailing the steps that were taken by the maker of the report to determine whether he or she did the right thing, so that if the certificate does not comply with those requirements, then its integrity will be called into question. Apart from that, of course, the court will expect the accused person to subject the maker of the certificate and the report to cross-examination, to poke holes on any shortcomings in the manner the certificate of the evidence was collected or generated. But essentially, the court would work with the certificate to assess whether the person generating the report and the certificate has complied with the law. There was a question about whether it's time that the court, the judiciary sets up a cybercrime court or a court dealing with cyber crimes. At the moment, the cyber crimes are being handled as part of the general crimes litigation. I agree that commercial centers such as Nairobi, it could be time that we set up particular the way we have the anti-corruption courts that specialize in cybercrime, because the world is going digital. Most of the transactions are being carried out online or electronically, and there is therefore a very huge upsurge in the cybercrime. In fact, the statistics show that Kenya lost about 2.1 billion in 2017 through cybercrime, and therefore I agree that it could be time that we consider in some of those large centers to have a court specializing in this particular area, and to also get judicial officers who preside over such courts sensitized on cybercrime. Just Kamau, I may have missed out on some of the other questions. Perhaps you could refresh my mind so that I can address those questions.
Musyoki, one of the questions I can see from Kwena is he's concerned that the forensic security, the cyber forensics community sometimes exploits, the issues of scientific approach to administration of justice. And how have the courts ensured that such exploitation do not happen? Because he feels that perhaps maybe if we do not understand the technical aspects, then the cyber forensics community are likely to take advantage of the judges who don't understand. So he's asking who certifies, verifies, and confirms the process, the source, authenticity of the digital evidence produced in courts. Do we have appointed institutions mandated to issue certificates referred to as a requirement to present digital evidence in court? But also for Mr. Mbatha, there was also a question where digital crimes have a social media footprint. Does the DCI work with social media companies? And are there examples where such have happened? The question is quite long, but I think it's on social media. Because it says that there are many of these platforms have opaque transparency. Then there's a question from Kenneth: what is DCI doing to boost general evidence handling in Kenya? Kenneth also wants to know about capacity building and hiring of cybersecurity experts into the department. Jones Baraza also talks about considering the vastness in the investigation and prosecution of cybercrime. Are there plans for collaboration between the DCI and the private organizations like KCSFA and others? So I don't know what the panelists, so they can also see these questions because they're also very long but very important, so that you can be able to answer them. So any of you can take the questions.
Well, let me take the question by Kwena on the courts dealing with this evidence, which is which he takes the view that very often the cyber forensics experts may be taking advantage of our lack of adequate knowledge in this area. It's true that we are not experts in some of these things, and we tend to rely wholesomely on the material that is placed before us by the experts, and we can only interrogate the certificate to confirm whether or not it complies with the law, and we can only then again rely on defense counsel to cross-examine the makers of these documents in order to test their veracity and their authenticity. And sometimes defense counsel are as clueless as we are, and if they do not do a good job, then very often, you know, we just have to rely on the material that has been brought to us by the experts. And we do not have any institutions that we can call upon to come and verify such material unless such third opinions or second opinions are sought by the defense to audit the reports or to prepare counter reports to those that are presented to us by the prosecution. And therefore, as the system is currently structured, remember ours is an adversarial system where the prosecution present their case, they place their evidence before us, and it is expected that the defense would challenge that evidence either by way of questions or by way of getting counter evidence, probably by getting experts in the same area to look at those reports and those materials, and then present a second view, which then the court can work with. But otherwise, we cannot independently, as courts, you know, approach other institutions to give us a second opinion on that evidence. I believe that is what I could say for now. The other questions you referred to, I think probably have more to do with the presentation by Peter.
Thank you very much, Justice Musyoka. I agree. Then now we put it over to Peter Mbatha.
Yes. First of all, I want to respond to the question by Odanga on issues of footprints related to social media. Yes. Most of these platforms and the institutions that offer the same services as public entities have collaborated with the DCI to ascertain the issues related to investigations. Through their legal departments, they have established collaboration and links that we can use to communicate with them and make requests on any criminal aspects touching on individuals who have used their platforms. Equally on the same, in the case of investigating cybercrimes such as scams, what jurisdiction does DCI have to obtain information? I would say each and every platform that exists is owned by somebody. And according to the laws of the land, each and every owner takes liability of whatever service they provide to the people of that jurisdiction. However, different jurisdictions, different sets of laws and rules that govern what they can disclose and what they cannot disclose to any agency that is requesting for information, be it for criminal proceedings or any other aspect that is being looked into, because we understand different jurisdictions have different rules and laws that govern them. Some things are criminal, have criminal aspect in our country, and in other countries they are not criminal in nature, and that is where these platforms are hosted or owned from. So in such cases, you find kind of lock up between the investigator and the people who own such platforms. So depending on the place where such a service is provided from, we'll have a different response to the request being made. In the essence, in the question by Kenneth on boosting general evidence handling in Kenya, like I had said when I started my presentation, that digital evidence requires a sound mind and a lot of integrity, because you mess with it, you may end up losing everything. And at that moment and time, you'll not be talking about digital evidence. You'll be thinking about some electronic devices you are holding for your own. So anybody who finds himself supposed to handle any evidence, to be very cautious so that they make sure that they don't tamper with the content of the said exhibit, because we understand most of the evidence, or rather, they contain volatile evidence that can be lost when we play around with it. Capacity building and hiring of cyber experts, I'll not comment on that for now. Excuse me for that. I may be in a capacity to do it. But my wish is that in the near future, we're going to assimilate as many experts as possible, because the cybercrime arena is growing fast day in, day out. A question by Baraza on fastness in the investigation and prosecution of cybercrime, and plans to call the institutions and organizations like KCSFA. I may not be in a capacity to comment about it equally, but I would say, being an organization and we move towards growing in the future, rather right now and towards the future, we should always wish to collaborate with state agencies that may support us in our due course as an organization. So I don't know whether there's any other questions that have not.
Thank you so much, Peter, for answering those questions. But there was one question on the social media, and the question was that, of course, when they were saying that many of the platforms have very opaque transparency rules, especially when it comes to advertising. So in the case of investigating cybercrime such as scams, what jurisdiction does DCI have to obtain information? And then the person was interested in finding out how can people contact you for further comments.
Let me start with the last question on how we can be contacted, or rather, one can reach us. The DCI Forensics Lab and the Cybercrime Wing is open for public anytime. You can reach us for consultancy by visiting the offices at the DCI headquarters. You'll always find somebody to attend to you and share your worries or your issues. So don't shy away from visiting the offices. They are very open to the public. The other one is on things related to scam. We've seen such in the past, not really long ago, but even during this time we're having COVID issues. I want to retaliate that the procedure for launching such complaints still remains. One has to report physically to the nearest police station or to a station of his choice, make a formal complaint, and then after making a formal complaint, they require to record a statement to that, and investigations are initiated immediately. And if the fraud touches on any social media, rather the crime in question here touches on any social media, there are laid down measures that are supposed to be followed to reach the platform that was used to perpetrate such crime, which will see the investigating officer reach out to them through their legal department and share the issues that are being investigated, and they get a response to it. And indeed, I will say compliance is being noted. they usually respond when they are called upon to handle such matters and issues. Thank you.
Thank you so much, Peter. There's a comment by Philip Mwangale. I think this is just a comment. His concern about the exploitation, as had been mentioned before. So he's recommending that there's need to have defense counsel who are adequately trained and have basic cyber forensic training, because he feels, and rightly so, that wholly relying on expert testimony is dangerous. So thank you very much, Philip Mwangale, for that. There's one question, and of course people want their questions answered privately, but I think it is also good that maybe because we've been seeing people coming in and out, Justice Musyoki, perhaps maybe you wanted to, maybe you can tell us who prepares the certificates and who are signatories to those certificates under Section 106B of Evidence Act, Cap 80, Laws of Kenya. So Chris will answer this publicly, because other people would perhaps maybe want to hear the comments. I think you had already mentioned that, but because a few people have come in after, maybe you made your presentation. Justice Musyoki.
I guess, Justice Musyoki, you'll need to unmute. You've not unmuted.
Sorry about that. The persons who should prepare the certificate, the conditions are set out in the Act. Essentially, it should be the person who, according to the Act, occupies a responsible position in relation to the operation of the device or the management of the relevant activities. That is, if the material was, say, made using a mobile phone, and then you connect this mobile phone to a laptop for the purpose of transferring the data from the mobile phone to the computer for the purpose of either getting a transcript or something, then the person who generated that material using the mobile phone and transfers it to the laptop would be the one to prepare the certificate, essentially because he would also be the person to appear in court and to give evidence on the processes that he went through for the purpose of generating the records that are to be presented to court. And generally, therefore, we are talking of the person responsible for processing that digital material from one device to the next for the purpose of preparing the same for presentation in court. That would be the person to make the certificate, whether the certificate it takes the format of an affidavit or not. The same case would apply to the computer printout that is generated under Section 65. Again, it will be the person involved in the process of, causing the printout to be made from whatever other device which carries the electronic material that is the subject of presentation in court.
Thank you very much, Justice Musyoki, and thank you so much, Alino Rikwena. I have taken your comment that you'd like us to hasten the collaboration between the judiciary and KCSFA, and you believe that should be greater help as far as scientific approach in justice administration is concerned. So we really appreciate that comment and all the comments that have been given to us. As has been mentioned, is that the proceedings have been recorded and they will be shared widely with you people. So don't be worried, even where you probably did not understand the answer. I believe that this is something that you'll be able to to listen to much later. I do not know whether there's anybody else who has got a question, because you can still unmute and ask the question, or whether this information now has been clear to you. I don't know whether there's anybody who, maybe I can see whether there's anybody who is interested in asking a question beyond the questions that were asked.
Just a comment. Odaga was asking on how we can reach the panelists beyond this webinar. Okay, my possible contacts will be shared by the president, KCSFA, to anybody who may be in need of them. He has everything related to my contact, so thank you. When you reach him, he's going to share everything.
Thank you very much, Mr. Peter Mbatha. And there was only one question that whether this act of the Cybercrime Act will borrow from electronic evidence. That is something also that had been asked. I don't know whether Peter Mbatha, you'd like to respond to that. And the reason I'm only saying this is because we want other people to also share in the answers that are being asked, because they are very, very important questions that I think very many people would benefit. The question was, kindly share on the Computer Misuse and Cybercrime Act, whether this will borrow from electronic evidence, because that is the last question that I can see that has not been touched on.
Thank you, Judge Jacqueline Kamau. I would request Judge Musyoka to comment on the same, please, instead of me, from the legal perspective, please, if you allow.
All right, thank you very much, Justice Musyoka. Maybe you can take that one, whether the Cybercrime Act will borrow from electronic evidence.
Thank you, Judge. The Computer Misuse and Cybercrimes Act 2018 essentially creates and defines offenses in this area. But what I should state is that the Evidence Act governs presentation of evidence in court, and it is a statute that applies to all crimes in the country. And therefore, that would mean that the provisions that I referred to, Section 65, Section 78A, and 106, would cover evidence with regard to offenses that are created under the Computer Misuse and Computer Crimes Act 2018. And therefore, the provisions that we've been talking about apply to crimes under this 2018 Act. I don't know whether that is satisfactory.
Thank you very much. I think if the participants have got other questions, maybe they can still forward them. And like Peter Mbatha has said, these are questions that we can obviously continue deliberating and share the answers through the contacts that are probably going to be given. So I think at this point, maybe the best thing would be to invite Mr. Kenny Zagira. He's the chair of the Kenya CyberSecurity Forensics Association, for him to give or to move a vote of thanks and to give the closing remarks. And I'm only saying this because I cannot see any other questions that have been asked. So welcome, Mr. Agira.
Hi, everyone. I must say I'm so much delighted with today's presentations. The judge has been to the point, Mbatha has also been to the point, and the questions that have also been asked, I think, are equally eye-opening. And they're also troublesome, even in court. Those who've been to court, I think they have seen all these matters. At times it appears as simple as such, but matters of electronic evidence, they say it can go either way. Whenever you think you have the best preparations possible, if the initial steps were not right, there is no magic you'll do about it. Once you mess it up, that's how it's called. It's that delicate and all that. And without much really on this, I would just thank all the participants and especially to the panelists. Judge, you made it very clear, and I think the issue of certificate, much as it's troublesome, you really done justice to it. Peter Mbatha, you've also done your part well. We know cyber forensics are equally wide. Now that it has various variants, you talk of these forensics, you talk of talk of networks and all that, but every journey must begin with the first step, and the first step in this case is what we are really having. Otherwise, thank you so much. Till next time. And to Madam President, you really moderated well. Thank you, and may God bless you.
Thank you very much, everybody, and have a good night and stay safe. Thank you.
Thank you.
Thank you.
Thank you.
Thank
Sure.
you.
Thanks.
Thank you, everyone. Thanks, guys. Thanks,
Thank you.
Peter.
Fuck you guys.